Okay, everyone, we're going to go ahead and get started. Good afternoon to everyone. My name is Kristen Kuzer. I'm the Provider Relations Manager for BHSB, and I will be your host today. BHSB is excited to collaborate with the Maryland Department of Labor to provide you with information about the Maryland Family and Medical Leave Insurance System, or FAMLI, FAMLI. This system will ensure that workers can take time away from work to care for themselves or a family member while still receiving job protection and earning a weekly stipend for up to 12 weeks. The contribution date will begin July 2025, with the availability of benefits beginning July 2026. This webinar presentation will take a deep dive into the family system process and also what your organizations can do now to prepare. Before I introduce our presenters, I'd like to review a few housekeeping notes. First off, please keep your microphone muted for the duration of the presentation. There will be a Q&A at the end of the presentation, so we kindly request that you hold your questions until that time. And if you're interested, please make sure to put your name, age, organization affiliation, and email address in the chat box. At this time, I'd like to introduce our presenters from the Maryland Department of Labor. We have Stacey Jefferson, the Community and Stakeholder Engagement Lead. And there's also Regan Vaughan, FAMLI's Director of Policy. So thank you so much. Please enjoy the webinar, and thank you both for being here to provide this information to all of us.
Thank you, Kristen, and hi, everyone. I know some of you from my previous role at BHSB. So I'm excited to be back with you all today, but in my new role with the Maryland Family and Medical Leave Insurance Division for the Maryland Department of Labor. And so today we will be talking to you about Maryland's forthcoming paid leave program. And we're excited to share with you. As Kristen said, if you could please hold all questions until the end. We do ask that you put those questions in the chat. Our presentation does build on itself. And so we may ask some of the questions as we get further into the presentation. Also, just to let you know, we're in the very early stages of implementation, so we may not have definitive answers for all of your questions today. However, we do also use your questions to help us as we work through implementation. And then also you may find your questions on future FAQs. And so with that, we want to get started. And so today, what we will be presenting to you is what is family, how a family will work, and what you can do now in order to prepare. And so many of you may know that the Maryland General Assembly passed the Time to Care Act in 2022, and this established paid family and medical leave insurance in Maryland. And what this does is ensures that workers have paid family and medical leave to take time away from work, receive job protection, and earn up to $1,000 a week for up to 12 weeks continuously or on an intermittent basis. And so there are several life events that are covered by family. This is very similar to FMLA for those of you who are familiar with that program. And so it's welcoming a child, and this includes fostering and adopting, the employee's own serious health condition, caring for a family member with a serious health condition, and preparing for a family member's deployment. And one thing I want to note here is that family member, the definition of family member is slightly different from FMLA. It is a more expanded definition for family member. There are more people covered. And Regan will get into this a little further in the presentation. And so Maryland is not alone. And as you can see from the map provided, there are several other jurisdictions that also have paid leave programs or forthcoming paid leave programs. And so in yellow, these are the jurisdictions or states that have existing paid leave programs. And then in red, this represents forthcoming paid leave programs. And so as you can see, several nearby jurisdictions provide paid leave, and this includes DC and New Jersey, And Delaware will also have a program coming online soon. And this helps us in Maryland because we're learning best practices from those states while also ensuring that we have the best program for Maryland's employers and workers. And so one of the things that we've been able to learn from other states are the benefits to employers. And we just want to share a couple of those benefits with you today. And so employers will benefit from reduced turnover and boosted morale, greater cost predictability while an employee is away, compared with the unpredictable cost that you often have to pay with an employee's wages while they're out. There's also higher workforce attachment, which I know is really important to the behavioral health community. Paid leave is shown in other states to bring women into the workforce and keep them long term. And this is especially important in Maryland because the comptroller's recent State of the Economy report revealed women have returned to the labor force at lower rates since the pandemic, particularly the 25 to 34-year-old age group. And then it also levels the playing field so that small businesses can offer this benefit that is usually offered by larger employers. And then we also want to acknowledge that we understand that you all play a dual role as providers by providing healthcare as well as also being small businesses. And so one of the things, a couple of the benefits that we want to highlight, particularly for you all, is that workers are better able to schedule and keep medical appointments. And then also there's improved mental health outcomes that have been shown by states that have paid leave programs. And now I'm going to turn it over to Regan so that she can go further into how the program will work.
Thanks, Stacey. Good afternoon, everyone. So we are working on a new timeline. The legislature gave us some additional time during the 2024 legislative session, which is giving us time to build our systems to make sure we're ready to go when contributions and benefits begin. So the timeline we're working under right now is that we expect our regulations to be published in the Maryland Register this summer. They are currently in draft form on our website and available to read and to comment on. We do expect to do one more set of draft regs on the website before we engage in the formal process by publishing them in the Maryland Register. But they are there. We are trying to collect as much information in advance as we can, because as Stacey mentioned, we've learned from previous states, and a lot of those states came out fast with their regulations and ended up amending them multiple times. So we're trying to get it as close to right as we can the first time. Once we have those regs finalized, everyone will be aware of the rules that are out there and how the program's going to work. They really set the backbone of the program. And we'll be ready July 1 of 2025 for contributions to begin. FAMLI is a self-sustaining program that is funded through contributions from both employers and employees, and doesn't tap into the state's general funds once we're up and running. And so employees will contribute through payroll deductions, and those will begin July 1, 2025. Employers will collect those payroll deductions and then have to put in their share of the contribution, and that'll be remitted to the state on a quarterly basis. And we're going to follow the unemployment insurance schedule. So the first contributions will actually be sent to the state by Halloween of 2025. And then quarterly after that. The state is going to build up a trust fund of those contributions so that on July 1 of 2026, we will have a solvent fund that is ready to handle the benefit claims that we start getting. And we'll be able to provide that wage replacement for employees who take time off. Now, as we get into the specifics of FAMLI, we found as we've done these presentations, it's easiest to compare it to a touchstone that most people are aware of. And for us, that's FMLA, the Family and Medical Leave Act. There are a lot of aspects of FAMLI and design aspects of FAMLI that are either exactly the same as FMLA or similar to FMLA. And our statute actually requires us to use FMLA's language when there isn't an explicit deviation from FMLA. So we're really trying to hold true to that. So for those of you that will have employees who qualify for both programs, there won't be a lot of sunlight between the two programs. If something qualifies for FMLA, it'll also qualify for FAMLI and vice versa. So the first thing there are those qualifying events that Stacey talked about. They are the same between FMLA and FAMLI in terms of being able to take time to care for yourself, to care for a family member, to welcome a child into your home, and to deal with the circumstances of a family member being deployed. Just like FMLA, the leave can be taken consecutively or intermittently. So that means your employee, if they need 12 weeks to recover from a surgery or 12 weeks of bonding time, they can take that all together and take 12 weeks off. Or if there's a situation where they break a leg and need to be off for 4 weeks, but then have a lot of physical therapy appointments afterwards, they could take that 4-week chunk and then spread out the leave over the physical therapy or the follow-up appointments. Just like FMLA, FAMLI requires health benefit continuation. So if your employee is participating in your employer offered health insurance plan, you would be required to continue that participation in the same manner as if they were reporting to work every day. Where they're similar, but with a little bit of exception, is job protection. FMLA provides job protection for those who qualify. FAMLI uses the same job protection language, but does have a very limited exception about undue burden restoring the person to the position. And also there is a job protection exception for self-directed care. So someone participating in the Medicaid waiver where they are self-directing their own care, they do not need to provide job protection, but it's a very narrowly written exception. The other place where we have some deviation is FMLA is really built off a 12-week annual limit. FAMLI has that 12-week annual limit, but there is an exception to that written into our statute, which allows someone who has their own serious health condition and welcomes a child into their home. They are allowed to take up to 24 weeks in a year. We expect to see this happen most often where the birthing parent is on bed rest for a few weeks and maybe takes 4 to 6 weeks for the bed rest. That does not eat into their 12 weeks of bonding leave. They would be able to take the full 12 weeks of bonding leave. But the statute does not require that pregnancy connection. So if we go back to our broken leg example, if someone breaks their leg and takes 4 weeks off, that too wouldn't interfere with the bonding leave. It just has to be their own serious health condition and welcoming a child to get those extra weeks in a year. So there's some areas where there is differences between FAMLI and FMLA. The first and the most obvious is FMLA is a federal law and FAMLI is a state law. And where that's important is we really can only push the edges and interpret the state law. as the Maryland Department of Labor. And so while I have my bucket list of things I would amend in FMLA or changes I would make to make the two programs work more seamlessly, we can only adjust family. And so where we can and where it makes sense, we do try to adjust it to align with FMLA. Another major difference between the two is FMLA, of course, is unpaid and unfunded. It only provides job protection. Family, on the other hand, is paid. It is a paid benefit. There is paid wage replacement. And so it needs that funding mechanism, and it has the contributions as part of it. A big change and kind of a big mindset change we're going to need to make between family and FMLA is how eligibility for the benefit is determined. In FMLA, it's very much based on your current position. Does the employer you work for qualify under FMLA? Do they have more than 50 employees? It's also very dependent on how many hours you've worked for that specific employer. Have you worked 1,250 hours for that employer over the past 12 months? Family, on the other hand, really looks at the employee's work history and not so much who they work for. There is no size limit or size qualification for family. All employers in Maryland are covered by family. No one is exempt under our statute. And so then when we're looking at whether an employee has enough of a work history to be eligible for family, we look at their complete work history in Maryland, not just for the employer for whom they're taking leave. So if an employee has 680 hours worked in the 12 months for which we've received contributions, the most recent 12 months for that contributions have been due, then that employee is eligible for leave. So for most employees, they'll have worked for that employer, they'll have some job history, work history with that employer, and will take the leave. But it is a portable benefit. So if someone has been working in Maryland and they start a new job, they could qualify from day one for the family benefit. And so that is really a big difference between family and FMLA. Another big difference, as Stacey referenced, is the definition of family member. So both FMLA and family allow you to take time off to care for a family member. But in the FMLA statute, it's really limited to the people who live with you. It's meant to be your minor children, your spouse, maybe a parent who lives in your household. But under family, we have a much broader definition of family member. It not only includes your minor children, but also includes your adult children. It includes your spouse, it includes your siblings, it includes your parents, your in-laws, your grandparents, and also grandchildren. And so there will be leave types that qualify under family because you're taking care of one of those family members that aren't included in FMLA, where the leave qualifies for family and doesn't qualify for FMLA. And then the other big difference between the two is an operational difference. In FMLA, it's the employer who processes the request, or someone the employer has hired to process the request. The employee brings it in, submits it to HR or whoever the person, the representative for the employer is, and sends their certification and information there. Family creates a central body, the Family Division within the Maryland Department of Labor, to process those claims, to make eligibility determinations, to approve the benefit, to set the benefit amount, and the state is set up to receive that information and to process that information. There is a caveat that we'll talk about later that an employer can choose to do a private plan and not the state plan, but it really takes that burden of processing the request off the employer under the family scheme. So I'm going to run through some of the frequently asked questions we get about our program and the design of our program. And the first is, what employers will participate? And this is where FAMLI really differentiates from a lot of the other employment laws in Maryland, in that all employers, regardless of payroll size, are required to provide their employees paid family and medical leave insurance. There are no exemptions in our statute. There are going to be a couple areas where we're preempted by federal law. So federal workers won't participate and railroad workers won't participate. But without federal preemption, there's no exemption. Everyone is a participant. If you employ a nanny in your home or have one person working for you, you are part of FAMLI and you are required to provide this benefit to your employees. Where we do have some deviation among employer types is the contribution amount and how we calculate what that contribution amount is. The initial contribution rate set by the Department of Labor is 0.9% of wages. And the statute really envisions that being shared equally between employers and employees. So for most employers, when they remit their contributions to the state, they'll be remitting 0.9% of payroll up to the employee's Social Security cap. So on the first 168,000 or so that an employee is earning. For those employers who have 15 or more employees, the contribution rate can be split equally between the employee and the employer at 0.45% of wages. The employer can pay more if they want to. They can cover all or some of the employee contribution, but employees can never pay more than 0.45% of their wages. The legislature did write in a contribution exemption for small employers. So that's with 14 or fewer employees. And for those employers with 14 or fewer employees, the employer is exempt from their half of the contribution. So when they remit contributions to the state, they're still required to do that. They will only remit 0.45% of the wages they pay. So the employee half, they're not going to be remitting the full 0.9%. We are keeping with the intent of this exemption. It is meant for small employers. So we are looking at all of the employees an employer has, whether they're in Maryland or not, to determine whether or not they get that exemption. And we'll be looking at the contribution reports that come along with the contributions made, the detail wages and hours for employees, to determine whether or not an employer has 14 or fewer employees. Where we do have a little bit of deviation is our statute allows self-employed individuals to participate in FAMLI. As self-employed individuals, they're not required to participate. It's an option for them. But if they do decide to participate, they have to pay the full freight, the 0.9% of wages. And we'll have more information later on how the self-employed program will work. I do want to point out, especially for this audience, that the legislature did include in the statute reimbursement for Medicaid providers, for community-based Medicaid providers. And all employers, whether they're Medicaid providers or not, are going to have to remit those contributions to the state. But the Department of Health is tasked with figuring out a way to reimburse Medicaid providers for the contributions made on behalf of workers who are operating under the Medicaid program. And that's something we have discussed with the Department of Health, but we don't have that process and procedure. They haven't announced what it's going to be yet. But there is that language in there that employers who are community-based providers under Medicaid should get reimbursed all or part of their employer side contribution, depending on their Medicaid their mix of funding with Medicaid and private sources. So as employers are looking at which employees are required to contribute and who contributions are due for, we get lots of questions about this, especially as a number of employers have remote workers in other states or operate in multiple states. And where we really did find consensus among the stakeholders that have been engaged in our regulatory process is to use the unemployment insurance rules. So unemployment has really detailed rules on how you determine if someone is localized in Maryland, if they primarily work in Maryland. And if someone's considered localized in Maryland, then you're required to pay Maryland uninsurance on that employee. And so we are adopting the same rules as unemployment to make those localization decisions. So your basic rule of thumb is if you are paying Maryland unemployment for an employee, then you should also be paying family contributions for that employee, and that employee will be required to make contributions as well. The eligibility for benefits is slightly different than who is covered for contributions purposes. We are still using that localization threshold. So it has to be someone who's been making contributions or for whom contributions are being made on their behalf. But in order to be eligible for the benefits, they have to have been working in a localized position for 680 hours over the 4 quarters for which contributions were made, the most recent 4 quarters for which contributions were made. We're going to have a little bit of lag time because we give employers that extra month after a quarter to get reports in. But if someone applies on November 1st of 2026, we'll be looking at the wage and hour reports that we've received that cover the period of July 1, 2025 through July 1, 2026. And because those wage and hour reports will come along with the contributions that employers send, we'll have the wages of the employee already and the hours worked. So we can make that benefit determination and the benefit amount determination without having to go back and forth with the employer. We'll already have a record of it and be able to make that determination quickly. So another big question we get is, how is family going to interact with time off that employers either already provide or are going to be providing? And this is one of those where we have a basic rule of thumb with a few exceptions, but the basic rule is employers are expressly prohibited from requiring workers to use their employer-provided time off either before or while they're using family. There's no waiting period. There's no exhaustion of leave before you can access family. However, an employer and a worker together can agree to use employer-provided time off to top off the family benefit. So just use some easy math. If an employee is used to $2,000 a week in wages and the family benefit maxes out at $1,000 a week in benefits, the employer and worker can agree to convert some of their accrued time off to bring their wages up to full wage replacement, to use half days or however the calculation works to have to get $1,000 a week also from the employer so that they're at 100% wage replacement. But again, that has to be something that's mutually agreed upon between the employer and the worker. The other caveat to this rule is if an employer is already trying to fulfill one of the purposes of family. The first of the Family Time to Care Act bills was introduced in 2013. So this idea of creating an insurance system in Maryland has been around for a while. And there are a number of employers who got out in front of it, who started having parental leave policies or have a really robust short-term disability benefit for their employees. And so if you're an employer who has a leave offering that's specifically designed to cover one of the qualifying events, so the most common is parental leave. If you have a parental leave policy, we are going to be referring to that as alternative family purpose leave. And if you have an AFPL policy, you are going to be allowed to require your employee to exhaust that concurrently with family leave. So one of the ways this could play out is if you offer 6 weeks of parental leave at 100% wage replacement, the employee can take those 6 weeks of your parental leave. And then when they apply for family leave, they're not going to be eligible for the full 12 weeks. You as the employer can let us know that you offer an AFPL, that the employee availed themselves of it. They took 6 weeks of AFPL for parental leave. And so when they apply for bonding leave with us, they would only be eligible for an additional 6 weeks. There are going to be some notification requirements there. And you're going to have to show us that you notified an employee about family, especially if during the claims process, you are going to assert that they don't qualify for family because they've already used leave in another way. And so those notice requirements are at the time of hire. You have to let employees know that family exists. You have to do it on an annual basis. If an employee is requesting paid leave, so if they're taking your parental leave, you have to let them know about family and that it could affect their family balance. And then if you know they're taking leave and it might be for a covered reason, you also have a responsibility to let them know about family. And I know this fourth one sounds a little squishy, and we're going to develop regs around it for you. But the basic rule of thumb here is if you throw a baby shower for someone and then they're suddenly going out on leave for 8 weeks or 10 weeks or 2 weeks or whatever it is, we're going to consider it that you knew they were taking the leave for a family reason. And so you were required to let them know about family. So when a worker files a claim, they'll file that claim with the Department of Labor using an online portal. We will immediately alert the employer that the claim has been filed. When you register with our system, you're going to let us know who to alert. It'll be through electronic means. So the email will go out saying your employee has filed for leave from your company. And you will have 5 days to let us know whether or not there's something we should consider while we're evaluating the application. This is when you would let us know, hey, this employee took 12 weeks of FMLA already, and I told them about family and they didn't apply for family. Or this week, this employee took 6 weeks of parental leave already. I told them about family. They didn't apply for family. They should only be eligible for an additional 6 weeks. Whatever the reason is, we will receive your input. If we don't receive anything in the 5 days, we're going to consider it a non-response, and that's when we'll begin processing the application from the claimant. We will then have 10 days to make a determination on the claim. Once we make that determination, we will alert both the employee and the employer whether or not the application's been approved, if it's been approved, for how long and when it's been approved, and also at least for the claimant, what the benefit amount is. Anytime there is a change in status to the application, we will also alert both the claimant and the employer. So a change of status could be a change in information. The doctor said it was only going to take 4 weeks to recover. Now they're saying 6 weeks. If we denied it and there's an appeal, we'll alert both parties. Anytime we have an adjustment, both the employer and the employee will be notified. So the state plan is really what this system has been built around, what the trust fund is built around, what our processes are being built around. And so after registration, employers are going to be automatically enrolled in the state plan. And it is going to provide a seamless way for employers to remit contributions. We'll be doing the application processing, issuing the benefits. We'll have a call center answering questions. And it's really intended to be a one-stop shop for both employers and employees to use. However, we know some employers would prefer to issue their own plan. And so there is going to be a way for employers to opt out of the state plan and opt into a private plan. And the private plans can come in 2 different forms. It can either be a commercial product sold by a lot of the companies you're probably working with now who offer short-term disability and other worker insurance programs. Or it can be a self-insured plan where the employer is administering it and can prove to the department that they're financially solvent and can handle any claims that come in. The commercial and self-insured plans have to offer benefits and protections that are the same or better than the state plan. And it is going to be an apples to apples comparison. 12 weeks, wage replacement formulas are the same or better. The criteria to access it are the same or better. Commercial plans are, in addition to being approved as meeting the requirements of FAMLI, are also going to have to comply with the insurance code. And there are a couple places where the insurance code is more favorable to employees. And so in those instances, the insurance code will prevail over FAMLI and have to offer the greater flexibility to employees. Employers are going to have to apply to offer the private plan, and there will be a fee along with that application to help cover the administrative costs. And the department will evaluate whether or not the plan they've selected is approved as meeting the requirements of FAMLI, or if they do a self-insured plan, whether the policy that's submitted to us meets or exceeds FAMLI. Employers and private plans are still going to be required to submit those quarterly wage and hour reports to the FAMLI division. They just won't have to also remit the contributions. And along with those wage and hour reports, they're also going to have to submit claims data to us so that we can ensure that employees are able to access benefits at the same rates and in the same manner as employees participating in the state plan. So I'm going to turn it back to Stacey to wrap us up, and then we will take questions.
Thanks, Regan. And so you may be wondering, what can you do now in order to prepare for the incoming program? And so we just want to go over a few of those things that you can do to prepare today. You can sign up to receive emails from the FAMLI team by going to our website. I'll also provide a direct link for you to sign up to receive emails as well in the chat. This really is the best way to stay up to date with us. Again, we're still in the very early stages, and as we're making changes, as we continue to build out the system, we continue to communicate with our stakeholders via email. Also, now is a good time to begin including family contributions in future budget planning. I don't know about you, but I know 2025 and 2026 is really not that far away. And so now is a really good time to start to think about how family will impact your budgets. And then also start thinking about how your existing benefits may interact with family. Regan mentioned that we know that there are employers that have a variety of benefit packages already. And now is a good time to start to think about how family will interact with them. And then also, Regan mentioned after registration, all employers will automatically be enrolled in the state plan. But there are other options that she mentioned as well. And so now is the time to start to think about whether or not you'd like to explore private plans. And so again, this is the best way to stay up to date with us. I'll also just quickly mention we can share a copy of the slides so that they can be sent out to everyone. And so now we want to open it up for questions. And if you could please put your questions in the chat and we'll get to as many of them as we can. Okay. One of the questions that we have so far is, does this plan cover contractual employees? What happens if a business is dissolved? How would claims be paid? All right, so let's take one at a time. Does this plan cover contractual employees?
So, if someone is an employee, which we are really looking at as a W-2 employee, someone you are paying wages to, you're paying FICA taxes for, and really qualifies as a W-2 employee, then they are covered by the plan if their work is localized in Maryland. If you are paying someone as a 1099 employee, so they are an independent contractor, then you are not required to pay contributions for them. And they would have the ability to opt into the program on their own. So that's the basic distinction. If someone is an employee, it doesn't matter if they're temporary or contractual, but you are paying them through a W-2, then they are considered covered by the plan.
The next question is, what happens if a business is dissolved?
So it's going to depend on which type of plan you're in. If the business is in a state plan, then the employees will still be covered. If they are taking leave for one of the qualifying events. If you are in a self-insured plan, you will have to produce a surety bond and show that you have self-insurance or financial ability to pay those claims that are outstanding when the business dissolves. And if you're in a commercial plan, the commercial insurer would still be responsible as long as the plan is still active. So it's really going to depend on which type of plan that the business is in and what stage of the claim the employee is in.
And then are state and local or county governments included?
Yes, there is no exemption for anyone in Maryland. So all of our government employers are also included in this.
So we have a question about the PTO to top off like your weekly payment by mutual agreement, and asking, will we have sample policy language about this?
Yes, so we'll definitely have language in the regulations about this. And then I do expect we'll have some guidance One of the things we've learned doing this is there's 180,000 employers, and I think 180,000 different leave and benefit packages and ways employers approach their leave and benefits. So we're trying to provide as much generic, adaptable guidance as we can, knowing that every employer is a little bit different. But we do want to be able to provide the right guidance here, so that this is a viable option for employers and employees.
And we currently don't have any more questions. Does anybody else have a question?
Stacey, I think there's one that is kind of buried in one of the chains about whether a parent has to be
I see it
in Maryland or not. And no, the person you're taking care of does not have to be in Maryland. If your parent lives out of state and you need to take leave to care for them, then as long as you have the proper documentation, then that is allowable.
Any other questions? Okay, doesn't seem like we have any other questions, Kristen. I don't know if you want to wrap up.
Sure. Yeah. Thank you both. We greatly appreciate your time today and all the information. I believe you had said that the slides will be sent out.
Yes, we can send them to you all so that you can share them.
Okay, perfect. Perfect. All right. Any last minute questions? It looks like there was oh, we already answered the question about PTO, correct? Yes. All right. If there's no other questions, we're going to go ahead and wrap this up. Again, we appreciate your participation and your time today. Thank you very much. And we will be sending out information. If you're interested, you can put your name, organization affiliation, and email address in the chat, and we'll make sure to record that. And again, if you have any further questions, please drop them in the chat. We'll keep it open for just a few moments, and then we'll close it out and give you some time back for the day. Thank you again, Regan and Stacey. Greatly appreciate it.
Thank you for having us.
Sure.